The envelope sat on my kitchen counter for 3 days before I finally opened it, and when I did, I couldn't believe what I was reading. A fine for $1,500 from the Meadowbrook Estates Homeowners Association, payable within 14 days, for allegedly violating community standards by painting my front door an unauthorized color. The problem was, I hadn't painted my door at all. It was the same forest green it had been when I bought the house 2 years ago in Raleigh, North Carolina. I'm Aaron Gallagher, a 34-year-old software engineer who moved to this seemingly peaceful suburban neighborhood because I wanted quiet and stability after years of apartment living. The house was a modest 3-bedroom colonial on Maple Ridge Drive. Nothing fancy, but it was mine. Or at least I thought it was mine until the HOA decided to make my life miserable. The letter was signed by Patricia Hendricks, the HOA president, and it cited Section 12.4 of the Community Covenant, which stated that all exterior paint colors must be pre-approved by the Architectural Review Committee. I read through the letter 3 times, my coffee going cold in my hand, trying to understand how this could have happened. There was no mention of a hearing, no opportunity to explain that the door had been this color since before I moved in, no chance to defend myself. Just a fine and a demand for payment. I immediately pulled out the closing documents from my home purchase. Sure enough, the inspection photos clearly showed the green door. I had never touched it, not even with a fresh coat of the same color. This was insane. The next morning, I drove to Patricia's house, which was conveniently located on the nicest street in the development. A sprawling 2-story brick home with perfectly manicured hedges and not a blade of grass out of place. I rang the doorbell at 9 in the morning, figuring that was reasonable enough. A woman in her late 40s answered, her blonde hair pulled back in a tight ponytail, wearing yoga pants and a designer tank top that probably cost more than my monthly car payment. "Can I help you?" she asked, her voice already carrying that edge of annoyance that some people seem to specialize in. "I'm Aaron Gallagher from Maple Ridge Drive. I received this letter about a fine and I need to discuss it with you. There's been a mistake." Patricia's eyes narrowed slightly. "There's no mistake. Your door is clearly painted an unauthorized color. The fine stands. But I didn't paint it. It's been that color since I bought the house. I have photos from the inspection." She crossed her arms. "Then the previous owner should have gotten approval. Regardless, you're the current homeowner, so you're responsible. You need to either repaint it an approved color or pay the fine. Those are your options. Don't I get a hearing or something? A chance to present my case to the board?" "The board has already made its decision. The fine notice is your notification. Now, if you'll excuse me, I have a very busy day." She started to close the door. I put my hand up, not touching the door but stopping her motion through sheer presence. "Wait, this doesn't seem legal. You can't just fine people without giving them a chance to defend themselves. I suggest you read your HOA covenant more carefully, Mr. Gallagher. You agreed to abide by our rules when you purchased your home. Good day." This time she did close the door, leaving me standing on her perfect porch feeling like I'd just been dismissed by a school principal. I went home and did exactly what she suggested. I read every single page of that HOA covenant, all 47 pages of dense legal language. What I found made my blood boil. While the covenant did give the board broad authority to enforce community standards, it also included a section on dispute resolution that clearly stated homeowners had the right to request a hearing before any fines exceeding $500 were imposed. The covenant even specified that homeowners must be given written notice of alleged violations, and at least 10 days to respond before any penalties were assessed. They had violated their own rules. I drafted a formal letter citing the specific sections of the covenant they had ignored, attached copies of my closing documents showing the door's original color, and requested an immediate hearing to contest the fine. I hand-delivered it to Patricia's mailbox and sent a copy via certified mail to cover my bases. 2 weeks passed with no response. The payment deadline came and went. I didn't pay the fine because I felt it was unjust, but I was getting nervous. I'd heard horror stories about HOAs placing liens on houses for unpaid fines. I started researching attorneys who specialized in HOA disputes. Then I got another letter. This one informed me that because I had failed to pay the original fine, late fees were being added at a rate of $50 per day. My $1,500 fine was now up to $2,200 and climbing. Still no mention of a hearing. Still no response to my documented request. I called the law office of Michael Chen, an attorney whose website showed extensive experience with HOA cases. His receptionist scheduled me for a consultation the following Tuesday. Michael's office was in a renovated building downtown, all exposed brick and modern furniture. He was younger than I expected, maybe late 30s, with sharp eyes that seemed to catalog every detail as I explained my situation. I brought every document: the original fine letter, my response requesting a hearing, the closing documents, the follow-up letter with increased fines, and a highlighted copy of the HOA covenant. "This is pretty clear-cut," Michael said after reviewing everything. "They violated North Carolina law and their own governing documents. HOAs are required to provide due process before imposing fines. That's not just good practice, it's the law. The state statute requires that homeowners be given notice of alleged violations, an opportunity to be heard, and a chance to cure the violation before fines are assessed. So, what do I do?" We send them a formal demand letter citing the legal violations and giving them one last chance to withdraw the fines and provide a proper hearing. If they refuse, we file a lawsuit. Based on what you've shown me, you have a strong case not just to have the fines dismissed, but potentially to recover damages for the violation of your due process rights. Damages. Like they would have to pay me, possibly. Courts don't look kindly on HOAs that abuse their authority. When an association violates a homeowner's rights, especially in such a blatant manner, courts can award compensatory damages, legal fees, and sometimes even punitive damages to deter future misconduct. I hired him on the spot. The retainer was steep, $3,500, but Michael assured me that if we won, the court would likely order the HOA to pay my attorney fees. The demand letter went out the next day. It was 5 pages of detailed legal arguments citing North Carolina General Statute Section 47F, the specific provisions of the HOA covenant, and case law from similar situations. Michael gave them 10 days to respond. Patricia called me directly on day 9. I was at work, writing code for a client project, when my phone buzzed with an unknown local number. "Mr. Gallagher, this is Patricia Hendricks. I've received a letter from your attorney, and I have to say, I'm very disappointed that you've chosen to take this adversarial approach. We're a community here, and we should be able to work things out like neighbors." The audacity was stunning. "Patricia, I tried to work it out like neighbors. I came to your house. I sent you a formal request for a hearing as specified in the covenant. You ignored me and increased the fines. The board stands by its decision. Your door is not an approved color. Then give me a hearing. That's all I'm asking for. Let me present my evidence to the board. The fine has already been assessed. You should have requested a hearing before the deadline." "What deadline?" "You never gave me one. You never told me I had any rights at all. You just sent a bill." Her voice got colder. "If you proceed with this lawsuit, the legal fees will be substantial. The HOA will fight this vigorously, and all homeowners will see their dues increase to cover the costs." Is that really what you want? To make yourself unpopular with your neighbors over a door color? I want what I'm entitled to under the law. If you just followed your own rules, none of this would be necessary. "You're making a big mistake, Mr. Gallagher." She hung up. I immediately called Michael and relayed the conversation. He sighed. "That's witness intimidation and possibly harassment. Document everything. Save all voicemails, texts, emails, everything. This woman is digging herself deeper." The 10-day deadline passed with no formal response from the HOA. Michael filed the lawsuit in Wake County Superior Court the following Monday. The complaint was thorough, laying out the timeline of events, the violations of my rights, the HOA's failure to follow proper procedures, and requesting relief in the form of injunctive relief to prevent further fines, declaratory judgment that the fines were invalid, compensatory damages for emotional distress, and the cost of defending myself, punitive damages for willful violation of my rights, and attorney fees. 3 days after the lawsuit was filed, I found a letter taped to my front door. Not mailed, not in my mailbox, but taped directly to the supposedly offensive green paint. It was from Patricia, written on HOA letterhead, and it informed me that I was now being fined an additional $500 for failing to maintain my lawn to community standards. I looked at my lawn. It was fine. Maybe the grass was a 1/4 inch longer than it should be, but it was November in North Carolina and the grass was barely growing. This was retaliation, pure and simple. I photographed the letter exactly where I found it, then removed it and called Michael. "They're retaliating. Perfect." I mean, not perfect for you, but perfect for our case. This demonstrates a pattern of harassment. We'll amend the complaint to add this new violation and request additional damages. The amended complaint was filed 2 days later. I also started documenting everything obsessively. I took photos of my property every morning and evening. I kept a journal of every interaction with the HOA. I saved every piece of mail. My neighbors started treating me differently. Some avoided eye contact when I waved. Others stopped to chat, expressing quiet support, but asking me not to mention their names because they didn't want to become targets themselves. One neighbor, an elderly man named Robert who lived 2 houses down, told me that Patricia had been running the HOA like a fiefdom for 6 years, and that several families had sold their homes and moved rather than deal with her constant harassment. She fined the Johnsons $8,000 because their son's basketball hoop was allegedly too visible from the street, Robert said. They were good people, just wanted their kid to play basketball. They paid the fine because they couldn't afford a lawyer, then sold the house at a loss and left. She's driven out at least 4 families that I know of. This information was valuable. Michael said we could potentially use it to establish a pattern of behavior, though we'd need those former homeowners to testify or provide affidavits. The HOA's response to our lawsuit came in late December. Their attorney, a firm called Morrison and Associates, filed a motion to dismiss, arguing that I had failed to exhaust internal remedies before seeking court intervention. It was a weak argument given that the HOA had refused to provide any internal remedy, but it would require a hearing. The hearing was scheduled for January 21st. In the meantime, the daily late fees continued to accrue on paper. The HOA was now claiming I owed over $4,000 in fines and fees for the door, plus the $500 for the lawn. They sent me monthly statements like I was supposed to just pay up. Christmas came and went. I spent it at my parents' house in Virginia, grateful for the break from the stress. My mother was furious when I explained what was happening. I raised you to stand up for yourself, she said. You fight this terrible woman. Back in Raleigh after New Year's, I focused on preparing for the hearing. Michael requested that I compile a timeline of all events, which took me an entire weekend. Every letter, every conversation, every piece of documentation, all organized chronologically with supporting evidence. The hearing on the motion to dismiss was held in a modern courtroom with fluorescent lights and uncomfortable wooden benches. Judge Marion Foster presided, a woman in her 60s with steel-gray hair and an expression that suggested she had seen every trick in the book. Patricia was there with her attorney, Dennis Morrison, a portly man in an expensive suit who looked like he was used to intimidating people. Morrison argued first, claiming that the HOA covenant required homeowners to appeal fines to the board before seeking court intervention. Michael countered by pointing out that you cannot appeal to a body that refuses to acknowledge your appeals exist, and that the HOA had violated its own procedures by refusing to grant a hearing in the first place. Judge Foster interrupted. Mr. Morrison, I've reviewed the covenant. It clearly states that fines exceeding $500 require a hearing before assessment. Did your client provide such a hearing to Mr. Gallagher? Morrison shuffled his papers. Your Honor, the board determined that a hearing was unnecessary given the clear nature of the violation. That's not what the covenant says. The covenant doesn't make hearings optional based on the board's subjective determination of clarity. It makes them mandatory for fines of this amount. Motion to dismiss is denied. This case will proceed to trial. I'm also issuing a preliminary injunction preventing the HOA from taking any collection action on these fines pending resolution of this case. She banged her gavel. It was a small victory, but it felt huge. Patricia's face was red as she left the courtroom, whispering furiously to Morrison. Discovery began in February. Michael sent interrogatories and document requests to the HOA, demanding copies of all board meeting minutes, all correspondence related to my property, all architectural review committee decisions from the past 5 years, and information about other homeowners who had been fined. The HOA fought every request, filing motion after motion to limit discovery, but Judge Foster mostly sided with us. When the documents finally came, they were revealing. The board minutes showed that my fine had been decided in a meeting where I wasn't mentioned by name at first. Patricia had simply said there was a problem property on Maple Ridge Drive that needed to be brought into compliance. The vote to fine me had taken less than 5 minutes, with no discussion of my rights or proper procedure. It also became clear that Patricia personally drove around the neighborhood looking for violations, using them as a way to enforce her vision of perfection. More interesting were the documents about other homeowners. In the past 3 years alone, the HOA had assessed over $150,000 in fines against various residents. Most had paid under protest. A few had fought back and eventually negotiated reduced settlements. None had taken it to court, until now. Michael also deposed Patricia, and I got to watch via video conference. She was combative from the start, treating Michael's questions as personal attacks. When asked why I hadn't been given a hearing, she said it wasn't necessary because the violation was obvious. When asked about the covenant requirement for hearings, she claimed the board had discretion to interpret the rules. When asked about the retaliatory lawn fine, she insisted it was coincidental timing. Miss Hendricks, Michael said calmly, you personally inspected Mr. Gallagher's lawn on November 18th, 3 days after the lawsuit was filed, and issued a fine the same day. You hadn't inspected his lawn at any point in the previous 6 months. You don't find that timing suspicious? I inspect properties on a rotating basis. Can you provide documentation of this rotation? It's informal. So there's no schedule, no system. You just happen to inspect his property right after he sued. That's correct. Michael let the silence hang. Even through the video screen, I could see Patricia was uncomfortable. The deposition of board members was equally enlightening. There were 5 board members total. Patricia as president, a woman named Karen Whitmore as vice president, and 3 others who mostly rubber-stamped whatever Patricia wanted. When Michael deposed Karen, she was more honest than Patricia probably would have liked. "Do you ever disagree with Patricia's recommendations?" Michael asked. Karen hesitated. "Sometimes I have questions." "Such as?" "Well, in Mr. Gallagher's case, I did ask whether we should notify him first and give him a chance to respond. Patricia said that would just delay enforcement, and that the covenant gave us authority to act immediately." "Did you review the covenant provision yourself?" "No, I trusted Patricia's interpretation. She's been president for 6 years and seems to know the rules very well." "Are you aware that the covenant requires hearings before fines of this amount?" Karen looked uncomfortable. "I am now. Michael sent me the deposition transcripts, and I read them with satisfaction. The case was building nicely. But trials take time, and while we waited for our court date, life in Meadowbrook Estates became increasingly uncomfortable. Patricia started showing up at neighborhood events I attended, making loud comments about people who sue their neighbors over nothing, and how some people just don't understand community standards. It was juvenile behavior from a grown woman, but it was also effective. More neighbors started avoiding me. Then in March, I received another notice. This one claimed I had placed trash bins at the curb on a non-collection day, which violated community standards. Another $500 fine. I had video from my doorbell camera showing that I had placed the bins out at 6:30 in the morning on the correct collection day, exactly when I always did. I forwarded the video to Michael, who added it to our growing evidence of harassment. "She's pattern-making for us," Michael said during one of our calls. "Every one of these retaliatory actions strengthens our case for punitive damages." The trial was scheduled for May 15th. As the date approached, I felt increasingly anxious. Michael assured me we had a strong case, but trials are unpredictable. Witnesses could perform poorly, judges could be having bad days, juries could be swayed by emotional appeals over facts. And if we lost, I could be on the hook for over $5,000 in fines plus my own attorney fees, which were approaching $15,000 at this point. The week before trial, Morrison called Michael with a settlement offer. The HOA would withdraw all fines, require no repayment of costs, and agree not to take any further action regarding my door if I would dismiss the lawsuit, and agree not to seek attorney fees or damages. It was essentially a wash, leaving both sides where they started. Michael relayed the offer. "It's not a bad deal considering the costs and risks of trial. You'd avoid owing them anything and you could move on with your life, but you wouldn't recover your losses and Patricia would face no consequences for violating your rights." I thought about it for maybe 10 seconds. "No. She needs to learn she can't treat people this way. We go to trial." "That's what I was hoping you'd say." May 15th arrived with unseasonably warm weather. I wore my best suit, a navy blue number I'd bought for job interviews years ago. The courthouse was busy with various cases, but we were assigned to Judge Foster again, which Michael considered a good sign. The trial was non-jury, which meant Judge Foster would decide the facts and the law. This was actually preferable in HOA cases. Michael explained, because judges understand the legal nuances better than juries and are less likely to be swayed by emotional appeals about neighborhood harmony. Morrison gave his opening statement first, painting me as a difficult homeowner who refused to follow reasonable rules and was wasting the court's time over a minor dispute. He emphasized that HOAs are necessary for maintaining property values and that some homeowners need enforcement mechanisms to keep them in line. Michael's opening was more pointed. This case is about power and abuse of power. The HOA covenant is a contract. Both sides agreed to follow certain rules. When Mr. Gallagher bought his home, he agreed to follow the HOA's standards. But the HOA also agreed to follow its own procedures, including providing due process before imposing fines. The HOA broke that contract. They decided their convenience was more important than Mr. Gallagher's rights. They decided they could ignore their own rules because they had the power to do so. This trial is about making it clear that power doesn't exempt anyone from following the law. I was the first witness. Michael took me through the timeline, having me explain each document and interaction. I kept my answers factual and unemotional, just as Michael had coached. When Morrison cross-examined me, he tried to make me seem unreasonable. "Mr. Gallagher, wouldn't it have been simpler to just repaint the door, simpler than asserting my legal rights?" Maybe. But the door wasn't the problem. The problem was being fined $1,500 without any opportunity to explain that I hadn't painted it in the first place. If they could do that over a door color, what else could they fine me for without process? Where does it end? So this is about principle. This is about following the rules. Both sides should have to follow the rules. Morrison tried to rattle me with questions about community harmony and being a good neighbor, but I stayed calm. The truth was on my side. Patricia testified next, and she was her own worst enemy. She was defensive and imperious, talking about how difficult it was to run an HOA and how some homeowners just didn't appreciate the work the board did. When Michael asked her about specific covenant provisions requiring hearings, she dismissed them as technicalities. "So the contract you and Mr. Gallagher are both bound by, the covenant that gives you authority to impose fines at all, that's just a technicality?" Michael asked. "That's not what I meant." "What did you mean?" "I meant that sometimes you have to focus on the spirit of the rules, not get bogged down in every little detail." The spirit of due process. What does that mean? Patricia had no good answer. She also couldn't explain why she had inspected my lawn days after I filed the lawsuit, or why the board had never granted me a hearing, despite multiple requests, or why late fees had continued to accrue at $50 per day, when the covenant specified a maximum of $10 per day. $50 per day, Michael repeated. Where in the covenant does it authorize that fee structure? It's in the enforcement guidelines. The enforcement guidelines aren't in the covenant. They're not part of the contract. Did Mr. Gallagher agree to them? All homeowners are subject to them. Answer the question, please. Did Mr. Gallagher specifically agree to enforcement guidelines that charge $50 per day in late fees? Not specifically, but thank you. The other board members who testified were mostly just embarrassed. They admitted they had deferred to Patricia's judgment, hadn't reviewed the covenant themselves, and hadn't really questioned whether proper procedure was being followed. Karen Whitmore, the vice president with the extremely appropriate name, was the most honest. "I should have pushed back harder," she admitted on the stand. "I knew something felt wrong about not giving Mr. Gallagher a chance to be heard, but Patricia was so certain she was right, and I didn't want to create conflict on the board. I regret that now." Michael also called Robert, my elderly neighbor, as a witness. Robert testified about the pattern of excessive fines and several families being driven out of the neighborhood. Morrison objected repeatedly, claiming this was irrelevant, but Judge Foster allowed it as evidence of the HOA's general practices. The trial lasted 2 days. Closing arguments happened on the afternoon of the second day. Morrison argued that while the HOA may have made some procedural mistakes, there was no real harm since I could have just paid the fine or appealed earlier. He also emphasized that I was still living in my home with my green door, so what damages could I really claim? Michael's closing argument was passionate. Mr. Morrison asks what damages Mr. Gallagher suffered. He suffered the stress of being threatened with thousands of dollars in fines for something he didn't do. He suffered the anxiety of worrying whether a lien would be placed on his home. He suffered the cost of having to hire an attorney to assert basic rights that should have been provided from the start. He suffered harassment and retaliation when he dared to stand up for himself. And beyond Mr. Gallagher's individual damages, this case is about something bigger. It's about whether HOAs have to follow the law. If this board faces no consequences for ignoring due process, what message does that send? Every HOA in this state will know they can violate homeowners' rights with impunity. But if this court makes clear that there are consequences, that HOAs are not above the law, then maybe other boards will think twice before acting like petty tyrants. Judge Foster took the case under advisement, which meant she would issue a written decision later rather than ruling from the bench. Michael said this was normal for more complex cases and didn't indicate anything about which way she was leaning. Waiting for the decision was torture. Days turned into weeks. I tried to focus on work, on my hobbies, on anything other than constantly checking the court website for updates. Michael assured me that Judge Foster was thorough and that a careful decision was better than a rushed one. Finally, on June 8th, Michael called me at work. We won, on everything. I almost dropped my phone. Everything. The judge issued a 30-page decision. She found that the HOA violated the covenant, violated North Carolina law, and violated your constitutional right to due process. She declared all the fines void. She ordered the HOA to pay your attorney fees in full. And she awarded you $25,000 in compensatory and punitive damages. I had to sit down. $25,000, plus attorney fees, which were now over $18,000. The HOA would have to pay over $43,000 total. The decision is scathing, Michael continued. Judge Foster basically accuses the board of running a shakedown operation. She cites the pattern of excessive fines, the lack of procedural safeguards, and what she calls concerning evidence of retaliatory conduct. She also notes that Ms. Hendrick's testimony was not credible on several key points. This is a complete vindication. I felt like I could breathe for the first time in months. What happens now? They have 30 days to pay or appeal. If they appeal, we'll fight it, but appellate courts rarely overturn factual findings like these. My guess is they'll pay. The HOA board held an emergency meeting 3 days after the decision. Karen Whitmore called me, which surprised me. Aaron, I want you to know that I pushed for the board to accept the judgment and not appeal. We voted 4-1 in favor. Patricia was the only dissenting vote. Thank you for calling to tell me. I also want to apologize. I should have stood up to Patricia from the beginning. You were right to fight this. The board has also voted to request Patricia's resignation as president. She's refused, but we're moving forward with a recall election. I think most homeowners are ready for a change in leadership. I appreciate you letting me know. I never wanted to be at war with the HOA. I just wanted to be treated fairly. You deserved better than what we gave you. I hope we can do better going forward." The check arrived 23 days later, $43,217.38. Michael took his portion for fees and costs, and I was left with a little over $25,000. It wasn't about the money, really, but it was satisfying validation. The recall election happened in July. Patricia fought it bitterly, sending out mass emails to all homeowners claiming she was being persecuted for trying to maintain standards. But the judge's decision was public record, and enough homeowners had read it or heard about it. Patricia was removed from the board by a vote of 73-19. Karen became the new president. One of Karen's first acts was to propose amendments to the HOA covenant, creating clearer procedures for violations, requiring hearings for any fine over $100, limiting late fees, and establishing an independent review committee for appeals. The amendments passed overwhelmingly. I saw Patricia around the neighborhood occasionally after that. She never spoke to me, just glared and kept walking. Her husband put their house up for sale in September. I heard they were moving to Florida. I couldn't say I was sorry to see them go. Life in Meadowbrook Estates got better after the leadership change. The new board was more reasonable, more transparent, and more focused on genuine community building rather than petty enforcement. They even held a neighborhood barbecue in August where several people apologized to me for not speaking up sooner or for avoiding me during the lawsuit. Robert, my elderly neighbor, pulled me aside at that barbecue. "You did a good thing, son. Not just for yourself, but for all of us. That woman needed to be stopped, and you had the guts to do it." I kept the green door. No one ever complained about it again. In fact, the new board officially added forest green to the list of approved door colors, along with several other reasonable options that Patricia had arbitrarily excluded. The money from the judgment, I donated half of it to a legal aid organization that helps low-income homeowners fight HOA abuses. The other half I put toward a vacation to Ireland that I'd been dreaming about for years. I figured I'd earned it. Michael and I stayed in touch. He told me the case had generated some interest in legal circles, and that he'd been contacted by several other homeowners dealing with similar HOA problems. Apparently, our case was being cited in legal briefs across North Carolina as an example of HOA overreach and the importance of due process. One afternoon in October, almost a year after that first fine letter arrived, I was sitting on my porch enjoying the fall weather when a young couple walking by stopped to look at my house. "Is this the house?" the woman asked her partner. "I think so. Green door on Maple Ridge." They noticed me and looked embarrassed. "Sorry, we didn't mean to be weird. We're looking at houses in the neighborhood and our real estate agent told us about what happened with the HOA here. She said things were different now, more reasonable." I smiled. "They are much better. You thinking about buying here? Maybe. We love the location, but we were worried about the HOA after hearing some old stories. The old leadership is gone. New board is actually pretty great. If you have any questions about living here, feel free to ask." We chatted for a few minutes about the neighborhood, the schools, the parks. As they walked away, the man turned back. "Thanks for fighting that battle, by the way. Our agent said if you hadn't stood up to them, she wouldn't even be showing houses here. You probably saved this neighborhood's reputation." I hadn't thought about it that way. I'd been so focused on my own situation, my own rights being violated, that I hadn't considered the broader impact. But he was right. If Patricia had continued unchecked, Meadowbrook Estates would have become known as a place to avoid, a cautionary tale about HOA nightmares. Property values would have suffered. Good families would have stayed away. By standing up for myself, by refusing to accept being treated unfairly, I'd inadvertently helped everyone. That evening, I sat at my kitchen table with a beer and thought about the whole experience. It had been stressful, expensive, and exhausting. There were times I'd wanted to give up, to just pay the stupid fine and move on. But I was glad I hadn't. Some principles are worth fighting for, and due process is one of them. The legal system isn't perfect. It's slow, it's expensive, and it's intimidating for regular people. But when it works, when a judge takes the time to read the documents and apply the law fairly, it can be a powerful tool for justice. Judge Foster had done exactly that. She'd seen through Patricia's bluster and the HOA's attempts to hide behind corporate authority, and she'd made clear that homeowners have rights that must be respected. I thought about all the people who don't fight, who just pay the unfair fines because they can't afford lawyers or don't know their rights or are too scared of retaliation. I'd been lucky in some ways. I had a good job that gave me financial stability. I'd kept good records. I'd found a good attorney. Not everyone has those advantages. That's why I was glad Michael was using our case to help others. That's why I donated to legal aid. Change doesn't happen when people accept injustice. It happens when someone says no, when someone stands up and demands better, even when it's hard. My phone buzzed with a text from my mother. Just read an article about HOA reform legislation being proposed in North Carolina. Says your case is cited as an example of why it's needed. So proud of you. I looked it up. Sure enough, a state representative had introduced a bill that would strengthen due process requirements for HOAs, cap late fees, and create penalties for retaliatory conduct. The bill's summary specifically mentioned recent court cases demonstrating the need for stronger homeowner protections. It might pass, it might not. Politics is unpredictable, but even the fact that it was being discussed, that legislators were paying attention to HOA abuses, felt like progress. As the sun set that October evening, casting orange light across my definitely not getting fined for it green door, I felt something I hadn't felt in a long time. Genuine contentment. Not because I'd won money or beaten Patricia, though those things were satisfying, but because I'd stood up for what was right, and things had gotten better because of it. The neighborhood was better. The HOA was better. My relationship with my neighbors was better. And I'd learned something important about myself. I was someone who could face down injustice and not back down, even when it was scary and uncertain. That winter, the new board invited me to join as a member. I declined, having had enough of HOA politics to last a lifetime, but I appreciated the gesture. Instead, I volunteered to help review and revise the community covenant to make it clearer and more fair. We spent 3 months working on it, a committee of 7 homeowners with different perspectives and priorities. The result was a document that actually made sense, that balanced the legitimate need for community standards with respect for individual homeowners' rights and property. The revised covenant passed with 84% approval in March. Karen called me after the vote to thank me for my help. "We couldn't have done this without you. You've really changed this place for the better." "A lot of people contributed," I said. "I'm just glad we're moving in the right direction." Spring came to Raleigh with its usual explosion of flowers and pollen. I planted a garden in my backyard, something I'd been wanting to do but had avoided during the conflict for fear of giving Patricia new things to complain about. Now I felt free to make my house truly mine. Tomatoes, peppers, herbs, and flowers. Nothing fancy, but it made me happy. My neighbor to the right, a woman named Grace I'd barely spoken to during the Patricia era, came over to admire the garden one Saturday morning. "It looks beautiful." I've wanted to start a garden, but I was always worried about getting in trouble with the HOA. Guess that sounds silly now. Not silly at all. That's exactly the environment Patricia created. She wanted everyone afraid. Well, she succeeded, but you weren't afraid. Or at least, you didn't let fear stop you. I was terrified, actually. I just decided I was more afraid of living in a place where I had no rights. Grace smiled. Well, thanks to you, the rest of us get to live in a better place. My husband and I were actually looking at houses in other neighborhoods last year. We're glad we stayed. Stories like that kept coming. A dozen different neighbors, over the course of that spring and summer, mentioned that they'd considered leaving during Patricia's reign but felt hopeful now. The neighborhood association, which had been moribund for years, started having well-attended meetings. People organized block parties and holiday decorations contests, and a community yard sale. The change in leadership had changed the entire culture. I ran into Dennis Morrison, the HOA's former attorney, at a local coffee shop one morning. He recognized me and, to my surprise, came over to my table. "Mr. Gallagher, I want to say something if you'll allow me." I gestured to the empty chair. He sat down, looking uncomfortable. "I owe you an apology. I represented the HOA board because that's my job, but I should have advised my client better. I should have told them from the start that they were in the wrong and needed to make it right. Instead, I took their money and helped them dig a deeper hole. That judgment hurt my reputation, and it should have. I just wanted you to know that I learned something from losing that case. I didn't know what to say at first. I appreciate you telling me that." I've turned down 3 potential HOA clients since then because they wanted me to help them do the same kind of heavy-handed enforcement. I realized I don't want to be that kind of lawyer. So thank you, strange as that sounds. We talked for a few more minutes about nothing in particular, then parted on friendly terms. It was a small moment, but it felt significant. Even Patricia's attack dog attorney had changed his perspective. As summer turned to fall again, marking 2 years since the original fine letter, I realized how completely different my life was. The lawsuit and its aftermath had cost me stress, money, and time, but it had also given me something valuable: confidence. I'd learned that I could face down bullies, navigate complex legal systems, and come out the other side stronger. That confidence spilled over into other areas of my life. At work, I negotiated a significant raise and a promotion to senior engineer. In my personal life, I started dating seriously for the first time in years, meeting a teacher named Zara Reynolds through a friend. She thought the whole HOA story was hilarious and admired that I'd fought back. "Most people just complain about unfair situations but never actually do anything," she said over dinner one night. "You did something. That takes real courage." We moved in together the following spring, renting out her condo while she stayed at my place. She loved the green door and insisted we plant an even bigger garden. No one from the HOA complained. In fact, the new Architectural Review Committee specifically complimented our landscaping in their annual neighborhood newsletter. The state legislation, inspired by cases like mine, eventually passed in a modified form. It wasn't everything advocates had hoped for, but it did establish clearer due process requirements for HOAs and created a state ombudsman office where homeowners could file complaints about HOA abuses. Michael called me when the governor signed it into law. "You should feel proud. This wouldn't have happened without cases like yours showing why it was necessary." I did feel proud. Not in a boastful way, but in a quiet satisfaction that something good had come from my ordeal. Other homeowners in North Carolina would have better protections because I'd been willing to fight. Years passed. Patricia never returned from Florida. Karen served as HOA president for 3 terms before stepping down, leaving the board in good hands with balanced, reasonable people. The neighborhood thrived. Property values increased. New families moved in, attracted by the location and the reputation of a fair, well-run community association. I kept that first fine letter in a drawer in my office, along with the court judgment. Sometimes, when I had a particularly frustrating day or felt like giving up on something difficult, I'd take them out and remember what I'd been through. It reminded me that standing up for what's right isn't always easy, but it's always worth it. The green door stayed green, of course. Eventually, it needed repainting, and I made sure to submit a formal request to the Architectural Review Committee and get written approval before lifting a brush. They approved it in 48 hours with a friendly note saying that forest green was a great choice. I had to laugh at the absurdity of it all. Zara and I got married in the backyard of my house, our house, with its approved green door and flourishing garden. Many of my neighbors attended, including Robert, who was well into his 80s but still sharp as ever. He gave a toast at the reception. I've lived in Meadowbrook Estates for 20 years. I've seen good times and bad times. I've seen what happens when fear rules a community, and I've seen what happens when people stand up for what's right. Aaron, you made this neighborhood better by refusing to accept injustice. That's a quality that will serve you well in marriage too. Everyone laughed, but I knew he was right. The skills I'd developed during that fight, the determination to stand up for myself, the willingness to endure discomfort for a principle, the patience to see difficult things through to the end, those were life skills that extended far beyond HOA disputes. Looking back, I wouldn't change what happened. I mean, I would have preferred not to be unjustly fined in the first place, but given that it happened, I was glad I fought. I was glad I didn't take the easy path of just paying to make it go away. I was glad I held people accountable for violating my rights, because that's what civilization is built on, really. Rules that apply to everyone, systems that are fair, consequences for those who abuse power. If everyone just accepted injustice because fighting back was hard, society would crumble. We'd live in a world where might makes right, where bullies always win, where having money or authority means you never face accountability. But when enough people say no, when enough people stand up and demand better, things change. Not overnight, not easily, but they change. My case was just one story among thousands, one homeowner standing up to one HOA in one North Carolina neighborhood. But it rippled outward in ways I never expected. Legislation changed. Other homeowners found courage to fight their own battles. A toxic HOA president was removed. A neighborhood transformed from a place of fear to a place of community. And all of it started because I refused to accept a $1,500 fine without due process. I refused to let Patricia Hendricks decide that her convenience was more important than my rights. I refused to be bullied. That refusal, that single moment of deciding to fight back rather than give in, changed everything. It changed my neighborhood. It changed HOA law in my state. It changed me. So when people ask me now whether fighting the HOA was worth it, I don't even hesitate. Absolutely, it was worth it. Every stressful moment, every dollar spent on attorney fees, every awkward encounter with hostile neighbors, all of it was worth it. Because some things matter more than convenience or comfort. Justice matters. Fairness matters. Due process matters. And someone has to stand up for those principles, even when it's hard, even when the outcome is uncertain, even when everyone is telling you to just let it go. I'm glad I was that someone. I'm glad I fought. I'm glad I won. And I'm glad that green door, the door that started it all, is still hanging on the front of my house. A daily reminder that standing up for what's right is always the correct choice, no matter the cost. The story could end there, with everything neatly wrapped up and lessons learned. But life isn't that tidy. There was a final chapter to the Patricia saga that happened about 4 years after the initial judgment. I was at work when Michael called me out of the blue. We hadn't spoken in over a year, though we'd stayed friendly. "Aaron, I have some news you'll find interesting." Patricia Hendricks was just arrested in Florida. For what? Fraud and theft. Turns out she was president of her HOA down there too, and she'd been embezzling funds. Over $200,000 over 3 years. The board got suspicious when she kept pushing for special assessments despite healthy reserves, and they hired a forensic accountant. Patricia had been writing checks to fake vendors and pocketing the money. I felt a strange mix of vindication and sadness. So she really was corrupt. Seems like it. The prosecutor down there actually reached out to me asking about our case. They're arguing that her behavior in North Carolina shows a pattern of abusing HOA authority for personal benefit. Our case is being used as evidence of her character and methods. Will they want me to testify? Possibly, though probably just in written form. But I thought you'd want to know that your instinct about her was right. She wasn't just a control freak or someone who took HOA rules too seriously. She was genuinely crooked. After we hung up, I sat at my desk thinking about Patricia. Part of me wondered if I'd pushed her toward embezzlement by getting her removed from power in North Carolina. But that was probably giving myself too much credit or blame. People who steal and abuse power don't do it because of external circumstances. They do it because that's who they are. The Florida case played out over the next year. Patricia eventually pleaded guilty to multiple counts of fraud and was sentenced to 5 years in prison, though she'd likely serve less with good behavior. She was also ordered to make full restitution to the HOA she'd robbed, though it was unclear whether she had the assets to do so. I did end up providing a written statement about my experience with Patricia, describing her authoritarian approach to HOA management, her disregard for rules and procedures, and her pattern of retaliation against those who questioned her. The prosecutor told Michael my statement was helpful in establishing that Patricia's conduct in Florida wasn't an aberration but a consistent pattern. Karen, the Meadowbrook Estates president who had replaced Patricia, called me when the Florida sentencing happened. I just saw the news. I feel terrible that we didn't catch on sooner to what kind of person she was. You did catch on. That's why you voted her out. But if she was capable of stealing that much money, I wonder if she was doing anything similar here. Maybe we should have audited the books more carefully when she left. Did you have any indication of financial problems? No, everything balanced, but I still wonder. I understood her concern, but I also thought it was unlikely Patricia had been embezzling in North Carolina. She'd been too focused on petty power and control, not money. The Florida situation had probably started after her ego was bruised by being forced out of power in Raleigh. But I kept those thoughts to myself and just reassured Karen that she'd done everything right. The news of Patricia's arrest and conviction spread through Meadowbrook Estates quickly. Some neighbors felt vindicated in their decision to remove her. Others felt guilty for having supported her for so long. A few even came to me to apologize for not believing me initially when I'd fought back against the fines. "I thought you were just being difficult," one man admitted at a neighborhood gathering. "I didn't understand that you were actually fighting a real abuse of power." "I'm sorry I didn't support you. It's okay. It's hard to see these things when you're in the middle of them." Patricia was very good at presenting herself as reasonable. She really had us fooled. Makes me wonder how many other HOA boards are run by people like her. It was a good question. I suspected there were plenty of small-time tyrants running homeowners associations across the country, most of whom would never escalate to actual embezzlement, but who made their neighbors' lives miserable through arbitrary enforcement and abuse of authority. Patricia was an extreme example, but the underlying dynamic, someone getting a little bit of power and using it to bully others, was probably pretty common. The whole experience made me more aware of how important it is to pay attention to local governance, even something as seemingly trivial as an HOA board. These organizations control significant aspects of people's lives and property. When they're run well, they can genuinely improve communities. When they're run poorly, they can make people miserable. And when they are run by someone actually criminal, like Patricia turned out to be, they can cause serious harm. I thought about writing an article or giving talks about HOA reform, but ultimately decided that wasn't my calling. I'd lived the experience and won my case. That was my contribution. Other people, like Michael and the state legislators who'd passed reform laws, could take it from there. I just wanted to get back to my normal life, and I did. Zara and I started a family. We had a daughter, then a son. Both of them grew up playing in that garden, running through a neighborhood that was now truly friendly and welcoming. They never knew the old Meadowbrook estates, the one ruled by fear and arbitrary fines. They only knew the community that had emerged from that darkness. Sometimes, when I was pushing my kids on the swing set in our backyard, I'd think about that first fine letter and everything that had followed. It felt like a lifetime ago, but also like yesterday. The stress and anger had faded, replaced by a quiet pride in having done the right thing. My kids would never know how close we came to leaving this neighborhood, how close their mother and I came to just giving up and moving somewhere without an HOA. But we'd stayed, and we'd fought, and we'd won. And because of that, they got to grow up in a place where rules were fair, where authority figures were accountable, and where standing up for yourself was valued rather than punished. Those were good lessons for them to absorb, even if they didn't know the specific story behind them. I wanted them to grow up believing that justice was possible, that systems could change, that individuals had power to make things better. Because all of those things were true, even if it sometimes took a fight to prove it. The Green Door eventually became a neighborhood legend. New families moving in would often comment on it, having heard the story from their real estate agents or neighbors. Some found it amusing, others inspiring. One family even painted their own door the same color in solidarity, which made me laugh. I created a trend, I joked to Zara. You created more than that, she replied. You created a community where people aren't afraid. That's worth more than any trend. She was right, of course. The visible legacy of my fight was that door color, but the real legacy was invisible. It was the knowledge, shared by everyone in Meadowbrook Estates, that the HOA served the homeowners, not the other way around. It was the understanding that rules had to be fair and fairly enforced. It was the culture of reasonable discussion rather than arbitrary dictate. Those things couldn't be photographed or pointed to, but they were real. They shaped every interaction, every board decision, every neighborhood meeting. The ghost of Patricia's authoritarianism had been exorcised, replaced by something healthier and more sustainable. And it had all started because I refused to accept a $1,500 fine without due process. Because I read the covenant and saw that they'd violated their own rules. Because I found a good lawyer and had the resources to fight. Because a judge took the time to actually read the documents and apply the law fairly. Because board members like Karen were willing to acknowledge mistakes and change course. Because neighbors eventually found their voices and demanded better. It took all of those things working together to create lasting change. I was just one part of a larger transformation, but I was glad to have been that part. I was glad I'd said no when it would have been easier to say yes. I was glad I'd fought when it would have been simpler to fold. And every time I walked through that green door, coming home to my family in our garden-filled house in our friendly neighborhood, I was reminded that some fights are worth having, and some victories echo far beyond their immediate consequences. That was the real story. Not just that the HOA fined me without hearing rights, and the court awarded me damages for violating my due process rights, though that was certainly part of it. The real story was about what happened after, about how one person standing up could inspire others, about how a small legal victory could ripple outward to change laws and communities and lives. The real story was about the neighborhood kid who would grow up without fear of arbitrary authority because someone had challenged that authority and won. About the elderly neighbor who could spend his final years in peace rather than under a petty tyrant's thumb. About the legislation that would protect thousands of other homeowners from similar abuses. About the toxic HOA president who eventually faced real consequences for her actions. All of it connected back to that moment when I opened the envelope, read the fine notice, and decided that this wasn't right, this wasn't acceptable, and I was going to do something about it. That decision, that simple refusal to accept injustice had mattered. It had changed things. Not just for me, but for everyone around me. And that realization, more than any court judgment or financial award, was the real victory. The knowledge that standing up for what's right, even when it's hard, even when you're standing alone, can actually make a difference. The green door would eventually need replacing, probably in another decade or so. But the lesson it represented, that lesson would last forever. It would last in the improved HOA covenant, in the state laws that now provided better protections, in the memories of everyone who'd lived through the transformation of Meadowbrook Estates, and in the example it set for future homeowners who might face similar injustices. Some doors are just doors. But some doors are symbols. Mine had become a symbol of resistance to arbitrary authority, of the power of due process, of the importance of standing up for your rights even when it costs you time and money and peace of mind. And I was okay with that. More than okay. I was proud. Proud of the fight I'd fought. Proud of the community we'd built. Proud of the legacy that would outlast me. That green door, the one that had caused so much trouble and ultimately so much good, would always remind me of what's possible when regular people refuse to accept being treated unfairly. When they stand up, speak out, and demand the justice they deserve. And that was a lesson worth any price.